And so I'm just going to spend a bit of time talking about immigration consequences of juvenile delinquency. And I'm really glad today that there are people here who work on the delinquency side, because yesterday I think there was one person and she looked really interested and everyone else just looked sort of dismayed, because the news is not great, but it also is, I think, important if you work on any part of the court system. But I'm going to just give you an overview of the immigration consequences of delinquency dispose, and then we'll just do a short breakout as well on some of those cases. But the basic idea is that, luckily for kids, juvenile delinquency dispose are not considered convictions for immigration purposes. And so that means that if you're used to, or you have worked with people in adult criminal court, or you have you're an immigration lawyer who deals with adult criminal convictions, the good news is that as long as the case is handled in juvenile court, whatever the disposition is not going to trigger any conviction-based problems in immigration. But there are two exceptions, or not exceptions, but two things to realize. One is that my understanding is that in Nebraska, a lot of cases for children, particularly 16, 17-year-old children, are filed in adult court. And so if you're a practitioner who represents children in any way who have been, might be going, might be coming from adult court, it's incredibly important that you are aware of the drastically different immigration consequences that will befall a child if their case is handled in adult or juvenile court. And to the extent that any advice is, my feeling, any advice is ever provided about the risks or benefits of either of those systems for a foreign-born child, it is essential that the child understand and that people be advised about the consequences. Because this special rule about it's not a conviction, it's not about the age of the person, it's about the form, it's about the place where the disposition happens. And so if the disposition happens in juvenile court, it will be much better in terms of immigration consequences. If the disposition happens in adult court, even if the person's only 16, they're going to have the same adult immigration consequences that attach to their conduct, their conviction. So that was the good news. This is just a slide on the recent Supreme Court case about the obligation to assess and advise on immigration consequences and how the Sixth Amendment right to counsel is implicated there. So just to be aware, this is something that, particularly for those of you who actually represent kids on the delinquency side or adult court, it's really important that you have a basic grasp of immigration issues, or that you find yourself an immigration lawyer to help out and assess those cases before you enter into any pleas, particularly for clients. So the reality is that even though the juvenile delinquency dispos are not considered convictions, it doesn't mean that they have no effect on an immigration case. And the reason why is that there can be grounds of inadmissibility and also grounds of deportability that are triggered by conduct. And so you could have an undocumented child who wants to become a resident, but the delinquency dispo may provide some evidence that there's a problem. Again, it's not the dispo itself that's the problem, it's the conduct that led to the disposition. And that's true also for children who are already lawful permanent residents, but who want to become citizens or at least don't want to get deported. The juvenile delinquency dispo on its own is not going to trigger a statutory deportability ground because it's a dispo. It's going to trigger it potentially because it's evidence or it shows that there's some conduct-based problem that the child is engaged in that's made them deportable. So I'm just going to run over some of the inadmissibility grounds that potentially can be implicated when you have juvenile court dispositions. And we talked a little bit about the grounds of inadmissibility earlier. These are the ones that, the hurdles you need to get over to get your green card. And luckily for SIJS and for the U visas, most of these grounds are waivable or inapplicable. So don't worry that you see these things and suddenly you think, oh, there's no hope for anyone. These are things that in some situations you can get around the grounds. But one of the grounds is if someone is drug addicted or is a drug abuser. It's a health-related ground of inadmissibility. And so if there's a juvenile delinquency dispo or multiple dispos for drug possession, that may give the Immigration Service some idea that the child has a drug problem. And again, it's not the dispositions themselves, but it's the fact, if indeed it's true, that the child has an underlying substance abuse problem. The way that this comes up is that, like you saw in the samples, when you apply for your residency, you have to submit a long application and you answer 1 million questions, including, have you ever been arrested, cited, have you sold drugs? You have to disclose a lot because you have the burden of showing that you're eligible for this benefit. So you have to disclose, and you, as the intending immigrant, have to tell the government about all of these things. And so when you disclose your arrests and you have 15 arrests and dispos for marijuana possession, it will probably raise some concerns about whether you have a drug abuse or drug addiction problem. So that's one thing to keep in mind. But again, it's not to say you shouldn't have a child go to drug court. If a child has a drug problem and it could actually be mitigated through drug court, in the big picture, that may be better than leaving the drug problem untreated and then having the child spin out of control with the drug problem. So it's not to say that because this might be triggered, you have to run in the other direction, but you just want to be aware as you're working on case dispositions how these issues can come up and how you may want to address them. You also may have, let me get this. You can read it while I drink my water. Another health-based ground of inadmissibility is tied to a physical or mental disorder with associated harmful behavior. This is an inadmissibility ground. Again, it's for an immigration-approved doctor to determine. But I would say that the place this may be most likely to come up would be a child who has dispositions for sexual abuse of another child. It's conceivable that that may fall into depending upon the facts of the case, could fall into this category of having a mental disorder with associated harmful behavior. Unfortunately, it is, I think, theoretically possible also to have people who have made multiple suicide attempts, and that comes up, to be designated as someone who has a mental disorder with associated harmful behavior to themselves. So that is something to be aware of as well. If you have a case, and these are actually, people in break were asking me, what kind of cases do you reject? And one of the types of cases I would say I think are very, on the SIJS side, very difficult ones are children who have dispositions or a history of sexual abuse of other children. Those are pretty much, I would say, per se, for my office, not going to be filed. And not because it's a statutory absolute bar, but there is a discretionary component, and I think that it's one of the areas where the Immigration Service, despite the fact that the child is probably a victim of abuse himself, they are not always very happy to see those kind of dispositions at all. So this is where some of the case rejects that I have, well, not rejects, but the rejections I make may be based on one of these grounds. We talked about it already, but the reason to believe drug trafficking. And again, if you have a child who comes into delinquency court, they're charged with possession for sale or sale. There's a police report that makes clear that they were possessing for sale or they're actually selling drugs. You know, if you can get that dismissed, that's great, that'll be helpful, but at the end of the day, it's the conduct and not the disposition that creates the inadmissibility problem. And so if you have a child with an arrest for drug trafficking, even if the case is dismissed, my feeling is that that will raise a red flag for the Immigration Service to inquire about the drug dealing. And if the child is represented by me and has to be honest, then we have a real problem on our hands, because at least for SIJS, this is not a waivable ground. But again, for the U visa, it is. And so if you have a U visa case on your hands, the more likely to get it dismissed or reduced, the better for the child, just to show that it wasn't treated as seriously perhaps as it could have been. Prostitution is another one, and this is people who have engaged in prostitution and procured prostitutes. And this is one that does, you know, we do see every so often, unfortunately. It's often girls and sometimes in the delinquency system. And again, it's the prostituting, it's not whether or not there's a disposition for it, but there are questions about that. Yeah.
Trafficking.
Yeah.
I'm sorry?
Could they be, is this waivable for trafficking?
Yes, yeah, I believe that it is. And so this is an admissibility ground. And so generally when we think of an admissibility, we're thinking of the millions of people who are doing family-based or employment. But for like a U visa or a T visa, a lot of these grounds are going to be either inapplicable or waivable. And so for a lot of the cases that are trafficking for sex trafficking, in many ways, you know, this would be a common attribute of that case. And so that's not going to be a bar for them. And hopefully the child who is a trafficking victim would not be being prosecuted for prostitution in a state court. It does happen, but I just hope there would be some negotiating there. False claim to U.S. citizenship, it's just like the worst thing a person can do.
It knocks everybody out, right?
Except for SIJS children. SIJS children, they could, you know, they could claim, but This is not claiming to your friends or your loved ones. This is a claim to sort of an official person who has some power to give you a benefit or not, or to take some action against you. So claiming you're a U.S. citizen to police officers, to the juvenile court is a problem. Filling out federal financial aid applications, saying you're a citizen, it's a problem. And so I think it's probably unlikely there would be some kind of prosecution in a juvenile court for this, but if you have a child who's consistently maintaining they're a citizen and they know they're not, and that comes to light even through a background check, for a lot of things, including regular family-based immigration, it's a big problem. And it is also a problem, it's a deportability ground as well. We're very protective of our status as U.S. citizens, and we can't.
Something like going for food stamps.
If you misrepresented your status to get the benefit, then you will have a problem. But again, keep in mind, if it's an undocumented parent with a U.S. citizen child, that child may be eligible for the benefit. So if the parent is going in and properly representing the child's immigration status and getting the benefit for the child, that's not going to trigger this. If the parent goes in and says, I was born here, I'm filling out this application, I'm a citizen, I want all the benefits, that will be a big problem. And it's something that the government can, catch. And I-9s for employment, saying I'm a citizen, that's another potential problem.
So you've got a juvenile case and you've got HHS screeching that mama's got to get a job or she doesn't get her babies back.
That's a case plan problem, I would say. From my perspective, that's probably more of a case plan problem than it is anything else, because the mother could misrepresent her status. She could go claim she's a citizen. She could work without permission.
She's being told she can't get her children back unless she gets a job and provides a home for them.
And to me, that's very problematic if she has no way to work legally.
Right.
And the only way to do that is to break federal law.
Exactly.
Well, or state law. Because in Nebraska, we have people who think.
Or state or federal law.
Impersonation.
Criminal impersonation. So it's a problem. It's a problem with kind of a one-size-fits-all approach to case plans, if there's not an acknowledgement of the immigration status in a real way of the people who are involved in some assessment of their limitations based on their status.
So, I mean, it could be set up to where they're screwed on this.
Yes. Mm-hmm.
By the people that are reporting to help them. Okay. Got it.
But they would ultimately be, their decision to make this misrepresentation is what would be dinged, so.
Christina, I just want to clarify this. On this one, if the parent of the child is the one who is falsely representing
The child's status. Mm-hmm.
that could affect the child, because, the child's not the one who's falsely representing their status.
So the question, I think, is about, do you have a parent who's misrepresenting the immigration status of the child? I think you have pretty good legal arguments about why the child should not be deemed to have made the misrepresentation. So I think you're probably going to be okay on that. It's a similar thing if someone brings a child in with a California birth certificate and the child is 4 years old and someone shows a California birth certificate for the child. From my perspective, that's not a misrepresentation by the child. So I think that there are probably good ways to get around that. And so the misrepresentation is really going to be linked to if the parent misrepresents their own status or the child misrepresents hers.
Well, and what about this? This was a specific case where mom claimed that she was born in the United States and that the child who was born in Mexico was a U.S. citizen by virtue of mom having been a U.S. citizen. And so the child throughout his life
Thought he was a U.S. citizen.
And so he would have represented himself as being a U.S. citizen. It's false, but it's unintentional.
Right.
Is there any exception to
There
this?
are, the question is like, oh my God, the kid really thought he was a citizen, he's not. There is an actual statutory exception to this, and I don't know it off the top of my head. There is an exception, but I honestly think it's pretty narrow. And you may have better luck arguing about the intent and the knowledge, but still I think there is a certain exception that I don't know off the top of my head, but it doesn't help. I've had kids in that situation come in, they really thought they were citizens, they found out a week ago they weren't, and unfortunately they don't fall in that category. Go ahead.
Yeah, is there any, knowing and willingly for
juveniles?
That's what we will argue or try to argue, but there's nothing clearly in the statute that's going to carve that out or say it's a false claim only after the age of 18. There's nothing black and white like that at all. It could be. I mean, Congress could choose to do that, but hasn't chosen to do that. But luckily, at least they did choose to make it inapplicable to SIJS kids. So at least for them, and again, this is, I think this is a waivable thing for UNT visas as well. So it's a big problem, but for a lot of these forms of relief that we're concerned with, it often can be overcome. Let's see, family unit, I just included a slide on this. This is at this point, I think unlikely that you'll see people with family unity cases, but it's just the one area where a juvenile delinquency disposition can actually be a bar and have direct problems like a conviction, even though it's handled in juvenile court. So the biggest issue for kids, I would say, who are undocumented and come into contact with the delinquency system is not necessarily that the disposition makes them ineligible for relief. It may be their conduct. But even if they have nothing, no drug trafficking, if what they have is vandalism, the biggest problem I would say that kids nationwide face is that it is a place where it makes it more likely that the child may get on the radar of the Immigration Service. If you have a prosecutor or a court or a probation department that is actively interested in turning over children to ICE, this is probably the most likely place that would happen. I would say that generally children who are going through like the 3A part of the court system, that's pretty unlikely, or at least it's not very common. But I would say that it is a more common thing on the delinquency side. And so I'm going to talk a bit later about immigration detainers, what to do if ICE actually does try to target a child who's in delinquency. There are certain kids who, if they're picked up by ICE, may be eligible for some kind of immigration relief. They might be SIJS or U or other things, but there is something I just wanted to touch on. It's called cancellation of removal. This is for non-permanent residents. And you may have heard some people say to you before, there's this kind of relief, I've been here for 10 years and I've been told if I'm just here for 10 years I can get a green card. And so the reality is that that's not the case. There is a kind of immigration relief that you can only apply for in immigration court, and it's called cancellation of removal. It has a 10-year continuous physical presence requirement, but it also has a requirement that you have to have a lawful permanent resident or citizen spouse, parent, or child, and you need to show that they would suffer exceptional and extremely unusual hardship if you got deported. And maybe 1 or 2% of those cases are approved every year. So sometimes people think, oh, I've got this option in immigration court. And some people do. Some people with profoundly disabled U.S. citizen infants do, but the vast majority of people who find themselves in immigration court may not be able to take advantage of this kind of relief. And even if a child could, one thing to keep in mind is that the juvenile delinquency dispositions can factor into any discretionary component of a judge in immigration court. And so even if there are no bars that are created by the delinquency disposition, it's still potentially a relevant factor for the immigration court judge to take into account. And so here on the grounds of deportability, these are the things to really be concerned about if you have a child who's already a permanent resident or has some kind of authorized stay here. Is a ground of deportability going to be triggered by some activity in the juvenile court? And again, the reality is that the juvenile court disposition, as long as it's juvenile court, is not going to be a conviction. So the conviction-based grounds of deportability will not be triggered. So that's the good news. The bad news is there's still a lot of conduct that a person can engage in as a resident that could get them on the road to being deported. Again, the drug addiction or abuse is one of the grounds. You also can have, again, unfortunately, the false claim to U.S. citizenship just keeps coming up over and over. This is also a ground of deportability. Violations against a protective order or against violent stalking or similar behavior. If you have a case of a child who may have a restraining order against him or her, a violation of it that's documented in juvenile court could also, trigger deportability ground. And again, there is cancellation of removal for people who are permanent residents, and it's a little bit easier to get that kind of relief for somebody. The requirements are a little bit less stringent. But again, they have to have been a permanent resident for 5 years and have been here for 7. So sometimes you'll have children who are residents, but they've only been residents a couple years. And so if they find themselves in immigration court, this kind of relief may not work for them because they don't have long enough time as a permanent resident. So if you want to take a look, if you take a look at page 116 in the materials I just provided for you, for those of you who are concerned about or interested in what it looks like to have people in immigration court cases, starting on page 116 is it's a document called a notice to appear, and it's the kind of document that will trigger, it's the filing document with immigration court that starts removal proceedings. And so in this particular case, starting on page 116, this is a notice to appear for somebody who was already a permanent resident. This person became a resident in 1997, but unfortunately, 10 years later, was convicted for drug possession, methamphetamine. So the first thing you think of when you see this is, ooh, this person should have naturalized, because if they naturalized after 5 years in 2002, we would not be here today with this immigration court case. But what you see is that this is an example of the federal government taking someone who's a resident and deciding that they're going to place them into removal proceedings, and this is what the charging document would look like. And I've also included a sample, and I think I'll get to it later, but there's also a sample in the materials of a notice to appear for someone who is undocumented. And you'll see that the charges are a little different. Basically, the charges are, you've been here, you're not here with permission, and so we want to remove you. Also for permanent residents, there can be some things that come up as a consequence of delinquency involvement. And this may actually come up when the person decides to naturalize. They are a resident, they're getting ready to naturalize, and then they have been in juvenile court. So a couple things can happen. If they decide to naturalize, it's going to trigger the Immigration Service taking a hard look at their case. And so if they have an arrest record, even if it's handled in delinquency, and they have to reveal all their arrests, and their arrests are 25 arrests for possession of marijuana, there's going to be a potential issue there, because the government may say, not only do we think you lack good moral character, which is a requirement, but we actually think you're a drug addict, and so we're going to not naturalize you. Instead, we're going to place you into removal proceedings because we believe that we now have evidence that you are a drug abuser. So it's an example of how, particularly for kids who have any juvenile delinquency or particularly adult court involvement, who want to become citizens, it's a really good idea to have that case analyzed by an immigration lawyer, because sometimes the process itself can end up being more destructive in a way if the people are actually not eligible to naturalize. And again, there's go ahead.
Does it make a difference, like, if a lot of time has gone by, like, for, kids are stupid when they're younger, but then years down the road,
So they're stupid when they're younger, and then they're unstupid later. And the question is there some help with the time? So one of the things is that what you'll see is that there's a good moral character requirement, and it's typically through the last 5 years before you naturalize. So the government's going to focus on that period. But they're not prohibited from looking further back. So in terms of the good moral character, the longer ago the arrest happened, the better off you're going to be. But if the deportability ground occurred 20 years ago, and it clearly made you deportable, and you're still deportable today, the passage of time is not going to erase that problem. And it's like a sad example, but I'll tell you, I was at the Ninth Circuit a couple weeks ago with my students, and there were two cases, one after the other. One of the respondents, the immigrant, was 70, and the other guy, unrelated to her, was 68 in a different case. The 70-year-old woman had committed an attempted murder in 1978, and she had come and gone from the US, I want to say 10 or 12 times, never having been flagged or targeted as deportable. She was a resident. She was actually married to a US citizen, veteran, and had 6 US citizen kids. But the last time she came and went from the Philippines, she came back in, her 1978 attempted murder or murder, whatever it was, popped up. And so now she found herself in removal proceedings, even though 30 some years had passed since the crime, because the crime itself made her deportable, and nothing that she did in the 30 years removed that problem. So, and the 68-year-old guy was a similar thing. It was a different kind of crime, but it was a late pickup for somebody who had become deportable quite a while back. So, yeah. But I would say generally it is true that the longer time passes, as long as nothing is a bar, if it's a discretionary thing, the longer that time passes and the more that someone has stayed out of trouble, the more likely it is that you can get a favorable discretionary exercise. And then just really briefly, there's just one sort of strange consequence for US citizens. Usually we don't think about delinquency dispositions affecting US citizens. There's a very limited area in which it can. If someone has a delinquency disposition for some types of sexual abuse by a child 14 or older, that US citizen may be barred from petitioning family members. The government has decided we don't want to let US citizens who may be a menace to children to be able to do family-based petitions. So it is something to keep in mind that the delinquency disposition in a case like this actually for a citizen can have pretty significant effects, because the disposition tied to the type of crime may make the U.S. citizen ineligible to immigrate a family member. Now, I would say the vast majority of U.S. citizens never need to immigrate a family member, so it may not be of great consequence, but it is something that, you know, is worth knowing as a small tidbit. And then the last thing is, referring children to DHS to figure out what their immigration status is, and DHS particularly, I mean ICE, is not a good way to go if what you're trying to do is get helpful information for you to better represent or help the child on your case. Because ICE, as much as it's part of and related to CIS in that they're all part of the Department of Homeland Security, its focus is enforcement. And so when you reach out to the enforcement arm of DHS, you're going to get enforcement. You're not going to get help, typically. And so there are other ways to get information about immigration situations. And I would say, particularly for those of you with HHS, if you look at page 109 in the materials, there's a nice short form that is page 109, 110. It's a document verification request. It cannot be filed by me as an immigration lawyer or by a lawyer representing the child in a juvenile court, if a GAL, but a state agency can actually submit this form to USCIS with any kind of documentation you have about the child, and they can run a search and report back to you on whether they have any records about the child's immigration case. And again, this can only be done by a state agency, but it is something that can be helpful if you have maybe the child has a work permit, you don't know if it's valid, you don't know why or what the child's status is. You as the agency could submit this request and get a verification. Again, you can also do Freedom of Information Act requests to the government, but typically, at least on the CIS side, that can be a very long process. So again, freedom of information, document verification, talking to an immigration lawyer is going to be the better way to gather information than to try to reach out to ICE to assess the child's immigration case. So it's just a warning there. So we're going to talk next about immigration court removal and detention, but we're going to spend, I'll give you 10 minutes, and you can pull out the other set of hypos, and these are about the juvenile delinquency issues. And I'm going to make the people who deal with juvenile court most analyze them most, and then give us the answers. On the people who work in delinquency. And we'll spend probably about 20 minutes, and then at 3 o'clock we're going to take a short break, and we're going to let our videographer change something on the camera and also just give you guys a chance to get up and stretch before the last hour. And before our break, Kelly's going to give some announcements as well. So immigration consequences, Akiko coming to the US from Japan, and a whole bunch of things have happened. How might her chances for gaining lawful permanent residency be affected by the drug issues, unfortunately, that she's had? Does anyone want to take a crack at the drug problems, the drug issues? It's okay. You look like you want to say something.
She says that she's not addict, but just with the, I mean, that hasn't been involved in getting a ticket for it, they can make those rounds.
Right, so there are potentially, she says she's not an addict, which is great, and hopefully that's true. But because she does have an application for permanent residency pending, the grounds of inadmissibility still do apply to her. And so the question will really become, does she have, she was arrested and charged with heroin possession, and she uses drugs, but she's not a drug addict. So I think the question ultimately is going to be, would a doctor certified by the Immigration Service find that she's a drug abuser? Probably not a drug addict. I think it's pretty clear if these facts are true. But there would be a concern about the drug abuse. And again, for SIJS, this is a waivable ground, the drug abuser or addict. But unfortunately for family-based immigration, it's not clearly waivable like SIJS. So you would want to make sure that if she were to be found to be a drug addict, abuser or addict, that there was some kind of ability to rehabilitate herself and resubmit the medical exam. You would want to be, frankly, if she has a drug problem, getting her some kind of treatment so that eventually she would be able to get around this ground of inadmissibility. If she had been charged with drug sales, anyone want to take a crack at that one? She's screwed. Sorry, she's screwed. And she's screwed she's not screwed because of the charge. I mean, it is a problem. But it's the drug sales that are the problem. And so, I think that when you have an application, say this was my case, and it's already on file, I'm already representing her, she's on the radar of the Immigration Service, she picks up a case for drug dealing, I would do everything I could in terms of first trying to get the case dismissed or get the charges changed to simple possession, but honestly, I would try to make some really great legal arguments about why, as a minor, she doesn't have the intent that you would need for the drug sales. I think I would do everything I could do to try to get around that, and it might work. It would be a case I would not file affirmatively, but if I'm in the middle of a case and that happens, we would try to do some damage control. And I'm not honestly sure exactly how the Immigration Service would treat it, but certainly it wouldn't be a case I would do affirmatively if there's a drug dealing. Go ahead.
Now, if she was picked up in removal proceedings, she would have some major problems.
And so if she was picked up, the point is if she was picked up and she was in removal proceedings, she would have major problems. And again, this is true because she could be on the radar of the Immigration Service, in front of an immigration judge, and if she has this problem, depending on whether the case are handled in adult or juvenile court, this drug issue may create a whole host of other problems for her if she were to wind up in removal proceedings. And again, the question was if her case is handled in district court rather than juvenile court. Our judge will tell us. Or maybe as a question.
I listened to a program a couple of weeks ago by Kevin Rooser, and he says, as far as this jurisdiction is concerned, 2 convictions, you're toast. And the other part about it was that, for instance, we see it all the time where they charge possession of marijuana, possession of drug paraphernalia on the same set of facts.
Mm-hmm.
He says if they plead both, that's 2 convictions as far as Nebraska is concerned, the way they prosecute it.
And so he's pointing out some things that Kevin Rooser, who's the big guru on intersection of immigration and criminal law. And so he's a go-to guy, and I think he actually has some publications he's done on Nebraska-specific criminal cases and how they affect immigration. Manual through the university. I would strongly suggest getting a copy of this, and particularly for those of you who are dealing with cases where children are being tried in adult court, not in juvenile court. And so for those kind of dispositions, if the case is handled in juvenile delinquency court, then the conviction-based grounds of inadmissibility will not be triggered. But again, these dispositions will factor in discretion. If the cases are handled in adult court, which is outside of what we're going to talk about, it's a whole other world of problematic, and Kevin is right, and it is true that even having a single drug conviction can be a problem, having multiple convictions can be problems, and so it's just one more reason, if you take anything away from the criminal side, is that you just want to keep kids in juvenile court. Whatever you can do, just keep them in juvenile court or get them into juvenile court. If they are not a U.S. citizen, that is going to be the best place for them to be. On their immigration case. And so, maybe there are other reasons that it would be better to be in adult court for them, but I think they need to understand the immigration implications so decisions, what to argue for can be fully informed. Because I think this most straightforward way to avoid the major problems is by keeping the case out of adult court, regardless of the child's age. Go ahead.
This might be a dumb question, but
Oh, no.
when the removal proceedings have already been started, is it always mandatory that that person is in holding, or are they sometimes, are they always detained?
Right.
That's kind of-
So the question is, if someone's in removal proceedings, are they always detained by the government? May they not be detained? The answer is that people are not always detained when they're in removal. And there are many people who are out fighting their cases, potentially, I've litigated some cases for 5 years, and they're not detained. But then there are many people who are in federal immigration custody while they're in removal. And so what we're actually gonna do after the break is I'm gonna go through kind of talking about from the moment ICE picks someone else or detects them and walk through the process of will they be detained, will they not, what would happen with their immigration case. So the answer is no, not everyone is, but there are certain people who have mandatory detention, and often the mandatory detention is because of a criminal conviction. So it's one more reason not to get an adult criminal conviction, because the child may actually end up in some ways triggering a mandatory detention provision because they have these adult convictions. So it's just one more plug for the juvenile courts. All right, Jesse, he's the long time. Oh, how might it be affected if she learns you're HIV positive? It used to be that HIV positive status was a ground of inadmissibility, but it is no longer. So to the extent that any of you had heard that and were concerned for a client or anyone, that has changed. And so certainly these inadmissibility grounds are statutory, and Congress can change them when they like, but usually it's in the direction of making them harsher and not usually in the direction of making them less harsh.
Well, I know it's inadmissible
The question was about if you have someone who's already entered and they're HIV positive, is that a ground of deportability? As far as I know, the health-related grounds are not deportability grounds, so except for the drug abuse and drug addiction, but I don't believe the HIV positive status, the communicable disease status, is one that would trigger deportability. And I don't know that for certain. That's my sense. It used to be.
Now, actually, if you are gay, transsexual, transgender, and HIV positive, you're then in
You have an asylum claim.
Yeah.
Go ahead.
So HIV standing alone will get you deported, but can they still take the fact that you're HIV connected with drug use and everything else and the argument?
The HIV will be an inadmissibility ground, not a deportability ground. It used to be an inadmissibility ground, and it is no longer. So this is not anymore the case. But say we were dealing in the past where it was an inadmissibility ground, but you find yourself in removal proceedings, and your theory is, I actually can't go back to Uganda because I'm HIV positive and I'll be persecuted there. You could get an asylum grant on that theory, and then when you adjust status as an asylee, there are waivers for certain grounds of inadmissibility. So it's not like they'll give it, I mean, usually it's not. They'll give it with one hand and take it away with the other. But again, the HIV status at this point is not something that has to be a concern, but it is true that for people who are HIV positive, they more than some others may have viable asylum claims because of the state, particularly if it's a claim tied to sexual orientation and HIV positive status, they may have a decent claim.
So there wouldn't be any circumstances where the HIV would fall under physical disorder?
It used to fall under, it was actually, I think it was not as much classified as a physical disorder with harmful behavior. I think the classification was more a serious communicable disease. There are another health-related grounds, and so people will be screened for TB. You have to make sure you have your immunizations, and I think it was more under that category and not really, it's a harmful behavior sort of category, but again, it's a health-related ground. You had a question, then you have a question.
Just if it were just HIV alone,
Right.
would that person be able to apply for a U visa if they had contracted it from someone else without them telling them?
So the question is about whether the person who contracted HIV from someone else might be eligible for a U visa. I think the first question would be, is the person a victim of a crime that's covered by the U visa? And I don't know the answer to that. I've never had someone come to me with a case like that. But to me, that would be the first question, because I think the question probably of harm and potentially if you reported and it was investigated. But I think the first question would be, do you even have on your hands a crime that someone could be investigating? And I don't know the answer to that question. I've never dealt with it.
Depends on the jurisdiction. I mean, there are some jurisdictions
Where it is
states
criminalized.
where, you know, if you're HIV positive and you know you're HIV positive, that can be considered a crime.
Right. So it would depend, I think, some state law specific things, but it's certainly, something to think about, but I don't know the answer. You had a question, then you had a question.
Lost in the concept.
Yeah.
Okay, adjudication or disposition in juvenile court is not a conviction.
Exactly.
However, the circumstances, the facts of that particular adjudication or disposition, the immigration judge might take that into, its discretionary decision for purposes of inadmissibility and deportation?
Right. The conviction doesn't create an inadmissibility or deportability ground, the delinquency disposition itself. It's the conduct that underlies it, and the conduct can do two things. The conduct may trigger a statutory ground of deportability or inadmissibility. Not the fact that there's a conviction, but the facts that underlie the conviction, or the facts that underlie the disposition may make someone deport, and that's not discretionary. It may make them deportable or inadmissible. And the disposition is simply evidence of the conduct, but it's the underlying conduct that triggers the inadmissibility or the deportability ground. If you're dealing with a form of immigration relief that's discretionary, if you're applying for immigration relief, then the immigration judge can factor in any delinquent conduct into the calculus of the discretionary decision. So there's certain acts a juvenile can do that will make him deportable or inadmissible, and there's not discretion on that. But where the immigration judge has, or the immigration service has discretion to grant or deny a benefit, the delinquent conduct can also be factored into that discretion.
So this idea that anything that happens in juvenile court doesn't matter.
It does matter in that it doesn't trigger conviction-based grounds of inadmissibility, right? But there are other bases, and so what happens is, say, we'll take Jesse, the longtime permanent resident. He's a resident. And what has he done? He's a gang member. He's been in the United States for a long time. He has a tattoo and he has a really long delinquency record. And it includes vandalism and some assaults. So he is picked up by the Immigration Service, and now they are seeing that he has all of these arrests, okay? And so the thing is, what are they gonna do? Is he actually deportable? Is there something, like, what can I do as the federal government with this kid who has a long delinquency record? And so the question here is gonna be, do the sustained petitions for the crimes or the gang affiliation make him deportable? And the answer to that is no, because if his case was handled in juvenile court, then those dispositions won't make him deportable. They do not make him deportable. But if the dispositions, like for example, instead of vandalism, there's 6 charges for being under the influence of a controlled substance. What happens there is that the juvenile dispositions tip off the Immigration Service that there's a conduct problem. So you've got 6 adjudications for drug possession, and the federal government says, this to us is evidence that he's a drug abuser. And it's not because of how you resolve the case in juvenile court. If the arrest shows up 6 times for drug possession, even if you managed every time to get the case dismissed, the government may say, we still think we have enough evidence. It may not be great evidence, but we think we have enough evidence to show that he's a drug abuser. So we're gonna put him in removal proceedings, and we're gonna let the immigration judge decide, does our evidence show that he's deportable? Have we been able to prove that he's a drug abuser? So the resolution of the case can matter, but it's not gonna trigger these statutory grounds of deportability. If this were an adult case, and I think that was one of the questions, maybe it wasn't, but if he had an adult case where he had 6 controlled substance possessions and they were all handled in adult court, if that shows up to ICE in a workplace raid, he is out. I mean, there's almost nothing he can do. There are some things, but there's almost nothing he's gonna be able to do to prevent his deportation. He's at least, at the very least, gonna be found clearly removable up front, and then he'll have an opportunity to try to apply for some relief. But ICE will say, you are clearly deportable because of your convictions. They're not gonna say that to a juvenile who had the case in juvenile court, because the dispositions are not convictions, and so they don't weigh as evidence in terms of deportability. But the conduct.
He could be in the removal proceedings.
Exactly,
Right.
exactly. Go ahead.
Is this drug abuse or addiction, does that fall under the health-related grounds, or is it separate?
It's a health-related ground of deportability. It's a health-related ground of inadmissibility. So if you're trying to get your green card and you've got that problem, it's an issue. But it also is an issue for you even after you get your green card. And so it is, I guess I wouldn't say it's health-related, but I think it's different, because in the context when you're applying for your green card, you do a medical exam and you get a doctor to say whether you're a drug abuser or a drug addict. When ICE is saying, we think you're a drug abuser or a drug addict, it may not be that their evidence is from a doctor saying there's a health problem. They may be relying on dispositions, particularly from adult court or juvenile court, that show this pattern of drug use that they argue adds up to evidence of drug abuse or drug addiction. So it's health related, but I would say that I don't think it's called that.
Confusion is, I thought the health-related grounds only applied to admissibility and not to removal.
That is true that there aren't medical exams you have to do to naturalize or to become deportable, but an HIV used to be a health-related ground. But this one, I think the government would probably say it's, I don't know that they would say health-based, but certainly they would say conduct-based, because their position would be, we don't need a criminal conviction or adjudication to deport someone for this reason. It's a conduct-based ground, and they probably would call it conduct as opposed to health-related, but either way, it doesn't rely on a disposition from court. So that's Jesse's problems here. One thing to know is that the Immigration Service is understandably very unhappy about gang involvement. I don't know how many gangs or how much gang involvement you have in Nebraska, but there's quite a lot in California, and so it comes up a lot. And there are currently, interestingly, no deportability or inadmissibility grounds for gang affiliation, although my Senator Feinstein has repeatedly tried to create one. But as the law stands right now, there is no gang involvement or gang affiliation ground. There are terrorism grounds, and there have been instances where the government has considered finding someone to be inadmissible as a terrorist because of their affiliation with a violent street gang. So it is something that's really important to keep in mind. I would say that for my cases, it's something I do screen really carefully for. And it doesn't mean that I file some cases where children have been seriously gang involved, but they've also been seriously rehabilitated. It's something that you want to be very careful with the Immigration Service, because I'll show you later, one of the enforcement priorities for ICE is people who are involved in gangs. Interestingly, they will say it's people who are 16 and older who are involved in gangs, but it's certainly a priority for them. They do recognize younger children with gang involvement probably have a whole host of other issues, but it's certainly something to be aware of. But it is sort of surprising that it's not, to me it's surprising, that it's not a freestanding ground of deportability or inadmissibility. And then we have, is there anything Jesse's parents can do to help? And I guess I mean in a direct immigration way, not in the general way of parenting their child. Is there anything that they could do to help him? And this is drawing back on something from this morning, and I'm happy to just answer it, but if anybody or anyone has a sense of what the parents could possibly do that could help him. He's 16 years old. He's unmarried. He presumably had been living in the custody, and hopefully would still be considered to be living in the custody of his parents. If his parents are lawful permanent residents, he's a permanent resident. If his parents naturalize and he meets all of those requirements for deriving citizenship, no matter how much gang banging, tattoo wearing, delinquent conduct there is, if his parents, one or both, naturalized and he met those requirements, the naturalization would actually flow through to him regardless of whether he's deportable, regardless of anything that he's done. So if you do have a lawful permanent resident child with facing some big problems in delinquency, you do want to inquire about the parent status and figure out either, number one, are they already citizens and maybe you have a US citizen child on your hands, or two, can those parents rush out and naturalize if they're eligible and prevent the deportation of the child through by operation of law. So it was sort of not a trick answer, but a complicated one.
Wouldn't he just be considered a citizen then instead of just a long-time lawful permanent resident?
If actually one or both of his parents had naturalized and he met those requirements, and we don't have enough facts here to know it, but if they had, then conceivably he would be. So even if ICE thought this is a deportable child, if you can come up with evidence he's actually a citizen, then immigration case is over. If he's in detention, he's released, you're out, as long as the government doesn't appeal. But either way, that would be your first and best line of defense, would be I'm a citizen. Because the government's only burden in removal for most people, particularly if they're undocumented, all they have to do is prove that you're an alien, that you weren't born here, and then they're done. And so if you contest that and say, no, actually, I wasn't born here, but I'm a citizen, you're still at the very beginning of the removal proceedings. And if you can prevail there, everything's over. So it's always a good thing to go to, but it rarely happens that easily. And then I'll just go over the last one. We're going to take a break for a few minutes to get the camera back on fixed up. But the last one is Lou, born in the Ukraine, became a citizen by operation of law. This is a hypo designed to get at the issues for US citizens who have sexual abuse dispositions. And so the first question was, what, if any, effect does his delinquency dispo have on his immigration situation? Again, he's a naturalized citizen, but it doesn't affect his own immigration status. He's a citizen now, as long as he didn't commit fraud to get his citizenship. He is protected from deportation. They won't strip his citizenship. What it could potentially do in this case is limit his ability to petition for other family members. If he falls into that strange and narrow exception, it's kind of like the foundling statute, a small, strange thing, but if he falls into the exception for delinquency dispositions that may bar him from petitioning other family members. Go ahead.
Doesn't he, because he was adopted by U.S. citizens, he doesn't have any more family members
If
that are outside that
right.
might not be U.S. citizens?
And maybe he wouldn't need that. Maybe he has some siblings out there. Maybe he gains some siblings. Maybe a parent dies and then I don't know. There conceivably could be some, or he goes on to marry someone and tries to immigrate her and her child. You could see that happening. The law has not been around long enough, I think, for that to play out. But it's not. Its primary focus actually is not on children. It's on adults. But it encompasses delinquency and adult criminal convictions.
And I'm familiar with one federal court case where it said, immigration case where it said that a foreign-born child who had been adopted by U.S. citizens and thus became a U.S. citizen himself could not petition to bring over siblings, biological siblings, because the adoption stopped the
Sibling relationship.
sibling relationship.
I think there's a lot of, oh, go ahead.
But I was going to say, but that's only one.
I think it's
one
wrong.
circuit, I'm not sure.
Right, and so if you're in the circuit with that prevailing law, you can have some problems on your hands. But if you're in a circuit that recognizes your ability to petition for siblings despite any adoptions that have taken place, and I would say that there probably is not a ton of case law on it, but in the absence of that kind of decision, you could probably pretty easily do those kind of adjustments for siblings. Oh, go ahead.
Is there any, there are strange cases that come up, and we do have an understanding of the concept.
Right.
Is there any disadvantage to dual citizenship? Some children are able to
Right.
pay their fee, then they can be residents or citizens of the world.
Right. The question is there any disadvantage to having dual citizenship? I would say generally not, that the US government allows for dual citizenship. So for a child to be acknowledged as a citizen of another country won't undermine their own US citizenship. You have to go through a pretty rigorous process to renounce your US citizenship. And so as long as the child's not doing that, you may not have a problem on your hands. I'm not sure if there would be other reasons per se that it would be not advisable. I certainly haven't had it come up in my cases. You could see, I mean, honestly, if you have a US citizen born child who's returning to the home country of their parent with a deported parent, you probably would want to figure out if the child is a citizen of that country because you want to know what the child's immigration status is going to be in that country. If you're sending the child back to a country where they have no lawful immigration status, at least someone wants to be aware of that and try to figure out if there's something that can be done on that front. Did you have a comment?
Well, yeah, actually, as far as dual citizenship goes, if you're going for any sort of security clearance,
You have a problem.
Top secret or whatever, and you're going through that whole process, forget it.
So one thing that's mentioned is the potential issues you might run across if you're trying to get some top secret clearance or job where you're going to be flagged as a dual citizen, that potentially that could be an issue. I suppose if a child acknowledged that citizenship purely and then renounced it later, perhaps there would be something to be done, but you could renounce it.
And you have to follow that country's laws
To renounce it.
with regard to renouncing that country's citizenship in order to qualify.
It's almost as hard to stop being a citizen as it is to be a citizen. Then you have a comment, and then we'll break.
Well,
Or a question.
I've had friends that are dual citizens, but like when they turn 18, they're required by law to either take the U.S. citizenship or foreign citizenship, which basically requires them telling an immigration official, I renounce my other citizenship. The catch is they never renounce it to the other country. They still maintain their passport.
Right.
So I guess in the eyes of the U.S. government, they have one citizenship, but
There may be situations where people are questioning about their dual citizenship, perhaps in like a process of some kind of naturalization. But I think generally speaking, the U.S. government is not, except maybe in these top secret situations, not antagonistic toward dual citizenship. But it is true that you would think about what is the function within the U.S., but then also how does this function from the child's country of origin. And did you have one of you have a question? Or?
Yeah, just on this fact pattern, it appears that Lou was committing these sexual assaults
Right.
prior to being naturalized.
Right.
So how is he not committing fraud in his naturalization
Right.
process by not disclosing that?
So in this case, initially the fact pattern is he's a U.S. citizen by operation of law. So in that case, if he's been able to obtain it through adoptive parents, he doesn't go through an application process to do that. So the first thing is that if the fact pattern is as we left it initially, he has not committed fraud because the law makes him into a citizen without the application process, which is exactly why it's kind of helpful, particularly for people like Jesse, who, if they had to naturalize on their own, would have like a world of problems. But in this case, if we make Lou into someone who has a pending green card application, then he does have some problems because if he has repeated dispositions for sexual assault might raise the idea that he has this mental disorder with associated harmful behavior, and that could be a bar to him getting his green card. But again, whenever you're dealing with people, citizens at birth or deriving the citizenship, that will happen legally and functionally without an application process. So the naturalization is really the place where, were he to naturalize, if he was a green card holder already, and he were to naturalize, he would have to disclose this information, and that potentially would be a problem for his naturalization. So we're going to take a break do you want to talk? Yeah, sure.
Make sure I understood.
Some people can stand up. Yeah,
Because he became a U.S. citizen through the adoption,
right.
whatever he did, it's not going to affect his citizenship.
Exactly.
So it doesn't matter, any of this stuff, and like the questions, how is age affected? That doesn't change it, he's not deportable.
He's not deportable, and the only reason age may factor in is if the delinquency adjudications were when he was 14 or older and he later wanted to petition another family member. The cutoff is 14. So that's the only difference. All right, so we're gonna have a break. We're gonna switch out the video, and so we'll come back at, I'll give you 8 minutes, 3:15, and then we'll have an hour and we'll finish up.